Hi, Mark Schwartz here, coming to you from my greenhouse with another episode of Research Innovations in Conservation Practice. And today I'm talking about a paper called Judiciary Independence: Why Should Conservation Ecologists Care? This is a paper that's just come out in Conservation Science and Practice, and the DOI is on the screen if you want to have a look at that and download it. It's an easy read. It's a perspective paper. It doesn't take very long to read. Apparently, there are proposed changes to the authority of the judiciary in Israel, and they're concerned about how this proposed change to the judicial system gives it less authority, and that there's concern that this could weaken environmental protection, diminish academic freedom, and reduce research on environmental issues. And so they have this paper with these three sections: impacts of the Israeli legal changes on ecosystems and the environments, impacts on research and education and ecology, and they're thinking on global relevance of this to environmental impacts and weakening of democratic institutions generally. This paper was submitted about 18 months ago, and I happened to be the handling editor for it. And I thought it was an interesting paper, but I also ended up thinking, well, maybe that's kind of specific to Israel, and wow, times change. Anyway, what do they conclude? They conclude that these judiciary reforms may infringe upon environmental and civil rights and our capacity to challenge our government to manage our environment in ways that we see beneficial. So in this series, I've decided to introduce this thing that I call the wheel of conservation practice. And that because it occurs to me that a conservation practitioner is a very vague term. It can mean wildlife managers, species specialists. It means development officers at NGOs, philanthropic organizations and how they direct their money, wildlife enforcement officers, environmental lawyers, people who do community outreach. A whole variety of different things constitutes conservation practice. And so I decided I would focus on which kinds of practitioners you might think would be interested in each individual paper. And I sort of go with, well, everybody on this one, because I think it gets down to our basic rights about environmental management. And the judiciary is very important in thinking about how rules are upheld and environmental management. And so I just pulled out four different examples here that how the judiciary has authority over environmental decision making may influence how philanthropic organizations donate money, how researchers approach research, and how environmental lawyers do their jobs. This has all of a sudden had amazing relevance to the United States because in 2024, the U.S. Supreme Court made a new ruling about what's known as the Chevron Deference. Basically, a previous Supreme Court decision that said that all things equal, the courts should give deference to the agencies who have specialists and specialized knowledge about decision making. And this decision removed some of that authority, removed the deference to the agencies, and put more of that decision-making authority into the hands of the judiciary. And this can have consequences. So imagine, for example, the Endangered Species Act. We know that endangered species are very idiosyncratic, and what constitutes endangerment for one species may not be the same across all species, nor recovery. And if we all of a sudden build case law around definitions of endangerment and recovery, it may be that it reduces the flexibility that's actually required given the variety of species that are out there. So I think this is an important decision that may have long-term consequences to how we manage biodiversity. And of course, after that decision, there was a whole series of editorials on that issue. But then now more recently, when we watch the headlines, we see the Trump administration challenging the judiciary. And now this is a 1-2 punch, because if the administration is successful in sort of bullying the judiciary into making decisions that are concordant with the administration's aims, then it really takes away that separation of powers, and there's no longer any check on the administration and its desires with respect to environmental management. And likewise, there's a series of editorials that address that issue. This has become all of a sudden a very important paper. It's an easy read. It has a lot of good ideas, and I encourage everyone to have a look at it. Judiciary Independence: Why Should Conservation Ecologists Care? This has been Mark Schwartz for Research Innovations in Conservation Practice. Thanks for listening, and talk to you next time.